from Africa now. We're joined on the line by Professor Lovemore Madhuku, who is based in Zimbabwe, a constitutional lawyer in Zimbabwe. Professor, thank you very much indeed for your time.
Yes, thank you.
All right, help us understand and just break down in layman's terms what we're talking about here, because the Constitutional Court here in South Africa has asked the parties to file these written submissions, not more than 20 pages, in light of Section 39(1) of the Constitution, whether this court is obliged to consider the United Nations International Covenant on Civil and Political Rights when construing sections 12(1)(b) and 35(3) of the Constitution. Break it down for us. What's your understanding with regards to the United Nations International Covenant on Civil and Political Rights?
Yes, thank you. I think the first point to note is that when the court asked the parties to file this submission, actually saying that those submissions were not properly focused on. In other words, there was not sufficient focus on those materials at the time the matter was argued, and that it is something that is going to be important in the determination of the judgment. And after the arguments, the judges went to debate the matter. You know that there were several judges there, about 10 judges, and I think that issue came up. And when it came up, it was then realized that not sufficient focus had been made on it. But Section 39 of the Constitution of South Africa is clear that they must consider international law. So they will certainly, the question that whether they should consider, the answer will be yes, they ought to consider the International Covenant on Civil and Political Rights. My own take is very clear. It is that the court did not give sufficient focus on that issue. And it ought to change the decision. I was listening to my colleague who was giving an opinion before I came in. I respectively disagree. I think that the focus on the international law will tell us a difference. The difference being that you know that President Zuma went to jail on the basis of contempt of court, that there was no trial, and that the basis upon which he was jailed was contempt of court. Contempt of court proceeds by their very nature tends to against the spirit of
Professor, we're losing you a bit. So the line is not too good, but I want to get absolute clarity on what you're saying with regards to this matter. If you can move around a bit just to improve that line. So with regards to due process being followed by the court, what's your opinion on that? No, I don't think... Professor, you know what? Let's drop that line. We'll try to redial you. Try again one more time and pick up on this conversation. I think it's important to get clarity on what the points that you're making. So we'll try to give you a call in the next few minutes. Professor Lovemore Madhuku, constitutional lawyer based in Zimbabwe.